223664. Counsel, if you're ready, you may proceed.
Thank you, Your Honor. May it please the court, opposing counsel. The appellate would like to reserve 5 minutes for rebuttal. As this court is aware, the appellate is here seeking a remand in this matter for an evidentiary hearing to determine whether he's entitled to a new trial based on newly discovered evidence. That newly discovered evidence is the recanted testimony of the only identifying witness in the case. We're also seeking a remand based upon the prosecutorial misconduct of the statements where she rehabilitated the erratic testimony of that witness. And third, we're seeking a remand with instructions to exclude all the improper and illegally obtained wire recordings of a phone conversation, especially those that were not of a criminal act. As this court is aware, Mr. Goldsmith was charged with dealing with a controlled substance. He was charged with selling one transaction of $160. That transaction does not fit under the definition of the 934-03 because it does not include an organized crime. You have to get under an organized crime before you can get into the balance of the statute and try to find the exceptions. So specifically, we'll address the question whether we should get a rehearing for the newly discovered evidence. And in that newly discovered evidence, the opposing counsel, the state, has said that we're not entitled to that because the affidavit presented to the court was not evidentiary evidence to be able to use before the court. In the amended motion for new trial that was filed, there was an affidavit submitted by a witness that said—
Was that an affidavit?
Sir?
Was that an affidavit? I didn't see any kind of jurat that shows that it was sworn. I saw a notary seal, which says that it was the
and
person
you may be
who it
correct
purported to be, but it wasn't a sworn affidavit.
You may be correct. I believe the witness swore that she heard the statement to the statement of that witness, but the person himself did not swear to it. You're correct. So
Okay,
that statement—
So there was a hearing on the second motion for new trial.
Yes, sir, there was.
So wasn't that your opportunity to demonstrate that you were entitled to new trial?
Well, there's two phases to that. The first phase is that you file the motion to see if the court will grant the evidentiary hearing based on the written documents before the court. The written documents before the court said that a statement was made by the witness that recanted her trial testimony. The responsibility of the court then is to say, well, based on that statement, if it's true, then we need to consider whether that's enough evidence to grant a new trial. And they should have scheduled an evidentiary hearing, had the opportunity to subpoena witnesses, had an opportunity to bring any other additional evidence that might be there to show why the recanting testimony was new, especially—
I'm sorry, I'm confused because I thought that actually, I'm unaware of this preliminary hearing to show whether we should have a hearing. That sounds like what we do in post-conviction motions. I've never seen it done for new trial. Is there any case or rule or statute that says that that's the way that we handle motions for new trial?
Yes, sir, Your Honor. In the Guzman case, they specifically said that they first considered the written documents that are there before the court. And once you've considered those written documents, if those are enough to grant the evidentiary hearing, you grant the evidentiary hearing. And
Okay,
in this case—
Guzman's a capital case, isn't it?
Sir, no, sir.
Okay.
This is a $160 transaction of a drug transaction. That's all. Was Guzman a capital? I don't believe it was, Your Honor. I can look.
Because that sounds like there was what they call a Huff hearing in capital cases to determine whether they should have an evidentiary hearing. Never seen that in a non-capital case, and I've certainly never seen it in a new trial context.
The statute, the 3850, the rule seems to provide that you have to file the motion first, and based on those written documents, then the court moves to an evidentiary hearing. If you do it otherwise, you would put the burden on either one party or the other, surprising the opposing counsel when you got to that hearing and say, well, I've got witnesses to present. The other side would have no idea that witnesses are going to be presented. And that would be a violation of due process for the defendant, or a violation on behalf of the state. The state would not be prepared to do that. In this instant, what the court did is said, well, there's somebody in the sitting out in the courtroom. Let's bring them in to testify without notice, without an opportunity to bring opposing witnesses. So we're going to do that. And for that reason, the trial counsel objected to that process, because it didn't seem to be proper, because there wasn't an opportunity for them to have brought their witnesses to the hearing. The first question is, can you get past the gate? Does the evidence that you're suggesting that you found raise to the level of enough to make a question whether that's going to grant a new trial? Once you look at the written filings, then you turn and go to open the gate, let's have an evidentiary hearing. If the evidence doesn't support the reason for a new trial, and you're weighing whether or not it's going to overturn that conviction. In this instance, we believe it would, because you've got the testimony, the only witness that saw him, the only witness that said the transaction took place, the only witness that said that he's the one that said he was going to sell me something and where we're going to meet. That witness, that is the only witness, made a statement that said, I lied. She also said that not only did I lie, but because the state was prosecuting me in another case, I was doing things to keep out of going to jail for another case.
I have a concern about the propriety of the second motion, but before I get to that, didn't the trial judge actually make a credibility determination in ruling on the second motion for new trial? And if so, how are we supposed to challenge the trial judge's credibility determination?
Well, he made a determination of credibility on a witness who was not in front of him. And as you pointed out, this was not an affidavit that was attached, so it was based off of a statement. He made a determination that I've not seen the person, I've not talked to the person, I've not looked at the person, but I'm determined that they are not reliable. So I'm not going to consider that testimony.
So isn't that often what's done in what I'll call the Huff hearing and in the preliminary hearings before post-conviction motions, is they determine whether the evidence presented by the defendant is credible enough to support a evidentiary hearing?
Well, in this instance, there was no opposing written documents. The state did not submit anything written to the court that said this is a false statement. In fact, the court, the state conceded at that hearing that, hey, this took place after the jury trial when we were here on another matter. They met each other out in the court anteroom and had some discussion. So the state knew this took place after the trial. So, the question is, do we believe her or do we don't believe her? But the real question is, does it affect the credibility of the state's identifying witness? And so without taking her testimony to determine whether her statements are true, I don't know how you can rely upon her reliability or not.
All right, I understand. So let me go back to my first question, which is, my understanding is that the 10-day period for new trial it's been called jurisdictional. Don't necessarily prefer that, but I've also seen it called inflexible. You have 10 days after the jury verdict to move for new trial. If you have, and in this case, this isn't something that happened at trial. This is new evidence that was discovered after trial, that the typical place that you raise such a claim is in post-conviction rather than new trial, which has to be filed in 10 days, and this wasn't. What difference does that make?
Well, there is the 10-day motion was filed for the new trial under prosecutorial misconduct. The other motion was originally filed without oath, and then the defendant was sworn to under it, making it a 3850 motion that could be filed.
Isn't this premature
that.
for a 3850 motion?
Sir,
This is premature for a 3850 motion. There hasn't even been judgment, much less an appeal.
no, it already been a conviction at that time. This is after the
It
jury
wasn't-
trial.
I mean, but it wasn't, go ahead.
I mean, I'm sorry if I don't understand that timing on that, but from what I've read, it was appropriate to be filed anytime after the conviction, as opposed to even after the appeal. So, but primarily, we think that there's a problem with that. The statute that the state misapplied, and that statute was the point and purpose of the motion in limine that was filed in the case. And the motion in limine was asking to exclude the testimony of the, all the evidence that was obtained by the phone
Mr. Moore,
conversation.
you may certainly proceed, but you're getting into your rebuttal.
Yes, sir, I see that.
Yeah.
I just want to touch base, then I'll reserve the balance, Your Honor. The recording of the statute says it's got to be a criminal act, and it's got to be a organized crime, and we can't find that evidence of one transaction qualifies as an organized crime. The Atkins court has restricted the application of that statute to the evidence of the criminal act itself. And recording a phone conversation between the parent and the child doesn't seem to be a criminal act. The element that he was charged with was sale, and sale does not have anything to do with what the parents are talking about raising their child. I'd like to reserve the balance of my time. Thank you.
Please the court, Adam Wilson on behalf of the state. We're asking that you affirm the judgment and sentence here and affirm the denial of the motion for new trial, or the 3850, whatever it was. As an initial point, I think it's important to point out this court's decision in Rogier, where you held that issues raised for the first, that are not raised in the initial brief, are considered abandoned. And so this whole argument about we didn't have notice, or this was really supposed to be the preliminary evidentiary hearing, and that we needed a second evidentiary hearing. None of that appears in the initial brief, and it was never actually raised in the lower court. It appears for the first time in the reply brief. So we would consider that to have been abandoned or waived. But even if it isn't abandoned or waived, I don't think there is a requirement to have a second evidentiary hearing. There's nothing in Rule 3850, or I've never seen any case law that suggests that there are two hearings in a post-conviction, a non-capital post-conviction case. Certainly the Guzman case that he cited, I don't think says that. In that case, there was a sort of preliminary hearing, and then there was no actual evidentiary hearing, and that was why it was reversed. But the court never spoke on saying that there is a requirement that you have two of these hearings. And so in this case, the actual issue before this court as to the motion for new trial is whether he was entitled to a new trial based on the evidence that he presented at that hearing. And when a defendant moves for a new trial on the basis of newly discovered evidence, he bears the burden of showing that the evidence is newly discovered and that it would have probably produced an acquittal on retrial. And if you don't produce any evidence, I don't see how you can meet that burden. And again, if you look at the record of that hearing, the defendant at no point suggests that, hey, we're moving too fast, this is only supposed to be preliminary. He seems to be acting under the impression that I have a piece of paper, which Your Honor correctly pointed out isn't an affidavit, isn't sworn, I get a new trial. He wanted a new trial. If you look at the initial brief, it was also asking this court, please remand for a new trial, not remand for an evidentiary hearing. Given that the defendant never introduced any evidence, I don't see how he could have established his burden of establishing newly discovered evidence that would probably produce a acquittal on retrial. As to the third issue, the recordings, again, this argument about organized crime, that I've never heard that wasn't even in the reply brief. That's appearing for the first time today. I don't know where that's from. There is no requirement that law enforcement be investigating organized crime before they have an informant wear a wire. The law is pretty clear, Section 934, that law enforcement or a person authorized by law enforcement can wear a wire to a drug sting if one of the parties to the conversation consents to the recording and it's for the purpose of gathering evidence of a crime. I submit to you that wearing a wire to a drug sting is obviously for the purpose of gathering evidence of a crime, even if it happens to include some conversations that do not strictly involve the actual hand-to-hand transaction between a drug dealer and the drug buyer. As to the second issue, the prosecutorial misconduct during closing argument, that was raised in the motion for new trial. That doesn't preserve it, so it has to be fundamental error. I submit to you that there was no misconduct whatsoever. The commented issue, I think, is when the prosecutor was reciting facts about how many drug buys the CI was involved in, and that's pretty much the point of closing argument, to recite evidence introduced at a trial. And even if it was slightly improper, it was an invited response to the defendant's closing argument, which focused heavily on the CI's credibility and the fact that she was lying, which is also an inference drawn from the facts. It's certainly not fundamental error. And if Your Honors have no more questions, the state asks that you please affirm. Thank you.
May it please the court. The issue of the objection to Lieutenant Maddox testifying was raised in the brief on page 16. He said he testified over objection to the defense counsel. And at that point, the judge also at that point in the time said there was an objection raised to his testimony, and the court said, I'm going to overrule your objection. We're going to go forward with the testimony. And this was not on notice that this person was even going to be appropriate to the court. So there was issues raised. They were raised in the brief. They were raised at the trial court. There were objections raised all through this, and specifically on the issue of the 934-03 exception, there were numerous objections raised as completeness, because there were recordings that were piece and part and piecemeal of recordings. Contrary to what the state said, the whole recording was not played to the jury. Only portions of the recording was played to the jury. The witness testified that one portion of it was a recorded text message, and yet her voice is on that recorded text message. That loops back around to the question of trying to rehabilitate this witness and saying she's testifying honestly to everything that's here before you. She was at the start of it. She turned left on second. That's all I know. Then there's the defendant testifying, change in me. I would never harm my son, etc. There's something from the confidential informant. The recording stopped. She's asked, what is that? He sent me a voice recording through text. Well, her voice is on that. There's no understanding of whose phone was used to make that recording, whether it was the police officer's phone or whether it was her phone. We don't believe it was the police officer's phone because the transaction had been completed, if it's according to her, later in the day, and therefore she recorded it solely on her own phone. She was not under direction of a police officer at that time, and that is strictly invasion of privacy. The state concedes that the only reason to record anything beyond the sale exchange, the portions that are criminal act is to identify the defendant. Well, that's not authorized under that statute. Under that exception, the 934 statute is extremely restricted, extremely limited, because the legislature said this is an exception to what we want to allow. And if you go farther into it, there's many things requiring warrants for most all of those. And I really believe that exception they have is for times of emergencies, when there's terrorism, life damage, property damage type things that would raise to the level of major crimes, which is what the other restrictive language at the start of the 934, the 934-01 is. It needs to be an organized crime and it needs to be a major crime. And we would suggest that the $160 transaction, single transaction with the defendant, is not organized.
Was this argument made in your brief?
Yes, sir, it is in the brief. So it's not major, nor is it an organized crime. And for those reasons, we would ask this to be remanded. And if there's no further questions, I'm out of time. Thank you much for your time, Your Honor.
Counsel, thank you for your argument. We have no other cases before us, so we are adjourned.
All rise.